Good evening. This is Rahul Reddy. We are live here from Houston, Texas. Every Tuesday from 5 p.m. to 6 p.m. Central Time, we do bring in immigration updates. Emily, what do we have today to discuss?
Today, we wanted to talk about the shocking news that came out last week about H-1B registration fraud. 50% of the registrations that were submitted this year turned out to be multiple registrations for the same individuals. And what is the impact of that? Does that mean there might be a second round of the lottery this year, which we didn't have last year? We also want to talk about bridging the gap when there's an issue between a delay in the H-4 approval being issued and the H-4 EAD approval being issued, even though they're supposed to be all approved together under the latest policy. What can you do if you are stuck in that situation? And we want to talk a bit about H-1B transfers and what are the risks involved when you start work for the new employer on the basis of the pending transfer using just the receipt notice. You haven't received the approval yet. What situations can come up there? What happens if your I-94 expires while your transfer is pending? And what happens if that transfer gets denied?
Emily, according to your stats, though, you came to a calculation that of the 100,000 applications that have been accepted by USCIS, 60% are still the duplicate filings. So out of them, which we know that most of them are fraudulent. There may be some people who may have a genuine 2 job offers that I've seen recently. I got feedback. There's a dentist who got 2 job offers from 2 different companies. There's one person who got from large companies. So, but most of them, what we been hearing, getting consultations, getting the feedback, definitely seems to be fraudulent companies. We have seen multiple other lawyers who were supporting this before, that as long as there is no collusion, as long as there is no ownership, it is perfectly okay to file with multiple companies. Is that true?
I think it's there are differing situations that come up. The number one issue is, even if you're submitting with multiple employers, is there actually a valid job offer? What we find when we dig into these cases is usually the worker, the beneficiary, is working for one of the companies. And so obviously they do have a valid job offer from that company. But the other companies that have submitted registrations don't have a valid job offer for them. Those companies have not vetted any of their education background. They didn't even have to go through an interview. They don't have a project set up. They're usually consulting companies. And what we find is when they get selected by the other company that they don't have a job offer with, that company then goes and files the petition. October 1st rolls around and they have the approval. And then the employee is placed on bench because they have no work for them. Unlawful benching, because they're also refusing to pay them because there's no work available. And then they tell them, well, we're going to start marketing you and we'll start paying you once you get on a project. And then the project comes in and it's in a different location. And guess what? The company fails to file an amendment. Now a site visit happens and USCIS shows up at the company location and turns out it's at a post office boxes, a UPS store or something like that. This is the common theme that we see over and over and over again. So yes, there are legitimate circumstances when people have more than one job offer, and as of now, they can submit multiple registrations, but the vast majority of them are the other situation where there is no valid job. They try to find one later and they're just skirting all of the rules, and then they end up with a revocation and a finding of fraud, and now the employee lost the cap number. And, you know, was it all worth it at this point? And I would say, no, it's not worth it. So if you've been playing around with the idea of, hey, I got selected, I'm going to go ahead and file when I'm in that situation, I don't recommend filing.
Emily, let me go over some of the things that I come across. Now, we do have 30,000 subscribers in YouTube, about 20,000 in Facebook, and of course we do have TV Asia. A lot of people subscribe to the TV Asia immigration things too. That's about almost 10,000 people watch every week. This I'm speaking about, and then I got feedback, and let me tell you some of the feedback. And now you analyze how many will there be a second lottery or not? The maximum that I heard, the people that got selected was, I think it's about 18 or 19. Somebody reported they got 18 or 19 selected. And then I have reports 4 or 5 getting selected is just very normal that I got report from. Obviously, the way they report is different, but yeah, that's been 18 or 19, I don't remember. Even that person doesn't remember it's 18 or 19. He has so many different companies, he can't remember whether it's 18 or 19. Then I have some reports, Emily, where I had some consultation people. And we do have daily conference call where people come and speak with us freely every day, as you know. I got reports that this particular person applied from a genuine company, but also gave his passport information to some other company. He got a job offer from that company, which is, you know what I mean. It's a little bit fakey thing. But here is what happened with these other companies that he contacted, though. He didn't get selected from the company that he got the job offer from. He got selected from some other company, and the same guy sent an email saying that, hey, buddy, you got the H-1B selected through one of my other company, which did not give a job offer, which we know what that said mean. These are the colluded companies, though. So he asked me, am I in trouble right now? Because he has filed with multiple different companies. I told there's a good chance. And what is the best solution? Go ahead and complain about this incident. That's the best solution, because at the later time, we can always refer that you did take the corrective action as soon as possible. Now, we see a lot of people are getting deported in the airports. We have seen some people getting misrepresentation. That's the biggest thing, is in the consulate, they're getting misrepresentation. And also they're getting notice of intent to revoke for some of these H-1Bs, although the scale of which hasn't been that much as much it should have been. All these things are from the last year, not in the before year, not this year, of course. And we see some discouragement now. A lot of lawyers have now come out and saying, yeah, this is all fraud. Let's not file these cases, even though they encouraged them to file this in the lottery, but they're not filing the cases because they are also fearful that the lawyers might go to jail too, because they are encouraging this kind of things too. So, Emily, what do you think right now? Is there going to be second lottery? If it's going to be second lottery, how much it's going to be? Now, they already selected a lot more than 85,000, 60,000 in the bachelor's category, 65,000 in the bachelor's category, and 20,000 in the master's category. They already selected more. Do you think so that there will be a second lottery? If so, how many number it's going to be?
Yeah, I think that with USCIS actually making this announcement last week or the week before, giving us the numbers, telling us that they see these duplicate filings as companies colluding together, and telling us that they are referring these companies for criminal enforcement, that should warn some companies that, hey, maybe we shouldn't be filing these petitions, and warn the beneficiaries not to file. So hopefully, if we're thinking half of those that were selected were fraud, hopefully those half don't file, which means it would open it up to potentially another 30 or 40,000 to be selected in a second round. We won't know until after June 30th if that's going to happen, but hopefully people are taking USCIS's warning seriously and not filing, which will then allow genuine applicants to finally be selected.
I have also a situation. I just want to report some of the situation recently. A couple of Dallas companies, though, they're just saying the employees, get out, we are closing the company. It is because of the notice of intent to revoke 221Gs they got, misrepresentations they got in the consulate. They are fearful that they'll be prosecuted, so that's the reason they're closing, though. So yeah, but I still don't think, I may not agree with you that all the people won't file. I know some of the people will neglect, but we'll see them when they go to criminal prosecution. We'll see them for consultations and other things too. But we strongly advise people, stay away from these companies, don't file. If there is no genuine offer, don't go with it. And if you know any of the companies, do complain. There is an H-1B fraud report that you can report to the USCIS, especially if you're not selected for the lottery. If you know the companies, please report them. These are the companies that have offered me to file the H-1B lottery without even going any of the technical interviews. So please report these companies. They're not worth. They should be put in jail. And the people who file for these H-1Bs, definitely, I strongly recommend to contact a lawyer, because you can take some corrective actions, maybe, that may protect it. We have seen misrepresentation. That means that you can never, ever come back into the United States. Not on H-1B, not on H-4, not on B-2, not on any other visa. Of course, there are some waivers available. That's a very tough standard. And you may require a qualifying relative, for example, a green card or U.S. citizen spouse, to get a waiver. And there is also an Haranka waiver. They're very tough waivers. They're going to cost a lot of money. What we recommend is to report these people. If you have not filed H-1B, do not file H-1Bs through these companies. It's not good for you. These people are going to jail. And some of these people, they disappear, Emily. They just go to India. And that's where the problem comes in. These employees, our life is ruined, and these employees make their money and run away. So definitely we need to warn the employees not to file H-1Bs with these companies. Anything else, Emily, before I go to the second topic?
Nope, I think we can move on.
Okay, Emily, the question that comes is that when there is a H-4 plus EAD extensions, though, you know, at one point of time, we used to get the H-1B and H-4 EAD together. Later on, the H-4 and H-4 EAD were not getting approved together. Of course, Stephen Brown, who was an architect of the lawsuit of the class action from our office, was able to get that when they approve the H-1B, they are supposed to approve the H-4 and H-4 EAD. What are the steps that people need to take to make sure that they don't have EAD interruptions, though? As you know, Emily, if they're working for a company, if they get interrupted, they get laid off, then they have to go back and join the company. They may not have a job. What are the steps that they need to do to make sure that EADs continue?
Yeah, number one would be, of course, the employer, the H-1B employer, so the spouse's employer, needs to be prepared to file the H-1B early. So you can file it up to 6 months in advance. So we recommend always, whenever you can, to file the extension as early as possible. So get started on that at the 6 month mark. And ensure that the company is going to be filing the H-1B, the H-4, and the H-4 EAD all together in one package all at the same time. We do still recommend premium processing. It may not be necessary in every case, especially if you do file early enough, but it just eliminates a lot of problems that happen and provide an extra level of customer service in case there is a problem that comes up. Beyond that, you want to make sure that the applications, especially the H-4 and the EAD, are filed properly. Sometimes when the H-4 and the EAD applications get separated, it's because the H-4 was filed properly, everything's ready to approve, but the EAD, maybe there was a problem with the photographs, or the photographs were missing, or there was a signature missing. There's always some little minor thing on an EAD, because you don't have to provide much in filing that, but just making sure that all of the documents and information are there when the 3 applications are all filed together. If you are in a situation where the H-1B is approved, the H-4 has been approved, but the EAD is still pending, you're still covered even if your current EAD expires, because you now have the extended H-4 I-94 that comes on your H-4 approval notice, and you have the receipt notice for your pending EAD extension that you filed before the current EAD expires. That gives you currently the 540-day automatic extension of the EAD, so that you can keep working while you're waiting for the EAD to be processed.
And also, if by any chance, Emily, the employer is not willing to file the H-4 plus EAD, what do you suggest to them?
Yeah, so in that situation, it makes sense to file the H-1B and H-4 together, file them early, file them in premium if you can, get the H-4 approval before your current EAD expires, and then on your own, you can file the EAD renewal. Now you have your H-4 I-94 extended already. You have the EAD renewal receipt notice. That again allows you to continue to work for the 540 days. But you need to have the H-4 I-94 extended for that auto extension of the EAD to kick in. If you've just filed the H-4 and EAD together, and they're both still pending and your H-4 status is expiring at the same time your EAD is expiring, you don't qualify for the automatic extension. You may have to then look at other options such as a trip to Mexico to show your spouse's H-1B approval notice and use automatic visa revalidation to come back and get your extended H-4 I-94 that way. Then you can rely on the automatic EAD extension.
Emily, I want to go to the next topic, especially people moving from company A to company B on H-1B. And some of these companies, of course, will not be willing to wait until the H-1B is approved. They want the people to join on the H-1B receipt notices. Now, obviously, the denials have not been as much as the Trump era, where we used to get a lot of denials. Almost every single day, we used to get a denial in our office. Now, of course, it's very rare to see the H-1B denials, but still, there is a risk there. What do you advise people when they are joining without the transfer approval? What are the risks, and if the H-1 gets denied, what are the options they have, Emily?
So I would first recommend that the transfer be filed in premium processing, because if you can get the decision on it with premium in 15 days, that means you may potentially still be within your 60-day grace period of when you left your previous employer. And that may then give you an option to, say, file a transfer to another employer that can get the approval, or refile the transfer with the company that had the denial. So getting a fast decision on the transfer, even if you've joined on the receipt, is very beneficial. The worst situation to be in is that you filed the transfer and you've joined the new company, and while you're waiting because they didn't do premium processing, your I-94 from the old company has expired. That puts you in a very tricky situation, because now that your I-94 has expired, you're technically not in H-1B status while the transfer is pending. You're in what we call a period of authorized stay, which is lawfully allowing you to stay, but it's not the same thing as being in H-1B status. Now, yes, you're authorized to work during that time as well while the transfer is pending. But the tricky part is if your transfer then gets denied after your previous employer's I-94 has expired, it puts you immediately out of status, and you're immediately starting to accrue unlawful presence. That means it's very difficult for you to get back into H-1B status without leaving the country and applying for a new visa stamp. So whenever possible, make sure you get the decision on the transfer before your old company's I-94 expires. If you're in that situation and you're within the 60-day grace period, there are much more options available to you. You could also consider, if you're concerned that maybe the transfer is going to get denied and your spouse is also on H-1B, you could file maybe a change of status to H-4 as a backup plan, just in case, and then withdraw that later if the transfer is successful.
You can always go, there's always a solution for you to go outside the country and get the H-1B approval, even though your transfer gets denied. And also, Emily, if the transfer gets denied, can we still use a 60-day grace period to file one more H-1B?
It is discretionary. So we've done it successfully in the past, arguing that it should be applied, but it is definitely not a guarantee to use the 60-day grace period if you've left the first employer for more than 60 days and now count it from the time the second employer's denial occurred. It may be possible if you can make some good arguments and can show that the transfer was improperly denied or something like that, but otherwise it could be tough.
Let's go to question and answer assembly. I have this gentleman who is on 485 EAD. Can he get his spouse into USA on just if he's working on EAD? The answer is no. But if you were on H-1B, you can resurrect the H-1B by filing an H-1B and getting the stamping of H-1B and get your wife on H-4. That is possible, definitely possible.
Mr. Ramachandra says, can we file a lawsuit against USCIS to set aside those H-1B selections for 2024 since they're acknowledging all of this fraud? I will say that that was attempted previously in another fiscal year. It was not successful at that time. Basically, the courts will give deference to the agency to decide how it's going to handle these situations when the regulations don't specify one way or another to do it. The regulations do give us the process for the electronic registration, but they don't say what happens in the event that fraud is found. And so they kind of leave that up to the Immigration Service. And so that case was not successful. What was successful out of that case is that USCIS kind of acknowledged that there is a chance that fraud can happen and claimed that they were taking actions to prevent it in the future. And now it's clear that they really didn't take the proper actions for that. But I don't know if a lawsuit would be useful in this situation. I think we have to wait and hope that USCIS denies those petitions that do get filed, that are those multiple filings, to be able to do later selections, or hope that people don't file when they shouldn't, and that will open up another round of the lottery.
I think so that even if the lawsuit may not be successful, Emily, there may be some things we may get out from the USCIS. Because last time when this lawsuit was filed, the USCIS said we are going to take all actions necessary to eliminate the duplicate filings. Now they're acknowledging that, hey, the duplicate filings have actually happened. Here's a question that comes out, is that there is something called it's not ripe, and what has already been done. For example, previously they said, well, we haven't done the lottery yet. Now they're going to say that it's already done. It's already over. We cannot go back and correct the things. So, however, a lawsuit might bring some light into the picture of how the USCIS is operating and how they would do going forward, though. That's what I believe in. But yeah, to find a lawyer to file a lawsuit for this one may be difficult too, because most of the people may have already represented employees who are selected in the lottery. For example, we have files for some of the people who have genuinely filed and got selected in the lottery. We may not want to argue against our own clients saying, put off the entire lottery system off. So yeah, it may be worth for you to find a lawyer to file a lawsuit. It may bring in some good things. Even if you may not win, it may bring in some good things in future.
Josh has a question. He transferred his H-1B and ended up working for a company that he worked for previously on OPT. Now, when you're on OPT, the company does not have to deduct certain taxes, the Social Security and the Medicare taxes. But when he transferred back on H-1B, the company continued to not deduct those taxes, which is improper when you're on H-1B. And he wants to know what happens now. We've already fixed it going forward, but what about going backwards? So it's not really an H-1B status problem. It's a tax problem, which does need to be figured out with the IRS. You may have to go back and file some amended taxes and have the company pay those taxes. I couldn't tell you what process is. That's going to be something that the company has to work out with the IRS and using their CPA, but I don't see it being a problem for your H-1B going forward because it's not really a status issue.
A couple of questions coming in on the duplicate registration. This gentleman got his H-1B picked in fiscal year 2023, got the H-1B approved, but he got the notice of intent to revoke, and he filed the H-1B with the same company again in 2024, got selected with only one company though. Am I eligible for the petition though? It will depend mostly on what was the reason why they issued a notice of intent to revoke for this particular company for the fiscal year 2023. Because this question is coming from TRT from YouTube. So if the company that you're saying that it's the same company filed in fiscal year 2024, we have Houston, we have a problem. Because the company that colluded before probably is involved in criminal things. Every time you're filing a petition, which is not a genuine application though, it is considered a felony for them to sign a H-1B petition. So when they have issued a notice of intent to revoke, this particular employer probably have already committed a felony in filing your application in 2023. Now, the same company is filing in 2024, we may have a problem there. So you may, at this point of time, consult a lawyer. Probably you need to get away from this company. The solution is that, yeah, you may have to give up your H-1B and have to go back to India and then try your lottery again or try your L-1B again. This is going to happen to most of the people that have got through this multiple registration previously, that are intending to get the through multiple registration to file this year. So this is very common situation that we see. They will end up leaving to India.
Arnab says, I entered on F1, went through OPT, STEM OPT, H-1B, now have my I-140 approved in EB2. Can I go back to F1 to do an MBA and then get back to H-1B after graduation? So assuming that the F1 is approved, yes, absolutely. Once you graduate from your MBA, you can file a change of status back to H-1B. You do not have to go through the lottery again. You've already been counted before, and your approved I-140 allows you to keep getting 3-year H-1Bs. It doesn't always have to be an extension of the H-1B. It can be a change of status to H-1B as well. As far as getting to F1, it's potentially doable. There's some potential that it could be denied. The main thing with the F1 is you have to show that you have non-immigrant intent, meaning you have a residence abroad that you don't intend to abandon, and that at the end of your program, you plan to go back to your home country. That may be difficult to do when you've been in the U.S. for so long, going from F1 to OPT to STEM OPT to H-1B to I-140. That's probably a good decade, I'm guessing. And also you have an approved I-140, which is an immigrant petition, which would suggest to the Immigration Service or a consular officer that you have immigrant intent. You plan on getting your green card in the U.S. So you may have difficulty getting that approved. I've seen them get approved, but just be aware that it's not a quick, easy process.
Question that comes from Gopi Tori from YouTube is that, does your law firm can predict whether it's the registration they have colluded or not? We can tell with a reasonable certainty, but not 100%. There are a couple of indicators, simple indicators. First, if you're working for the company, well, we don't investigate any further. And you got selected in the lottery, we don't investigate, period. That's it, you're good. You're already working for the company, you got selected, no investigation, don't contact us, you're good. Now comes the question that if you're not working for the company, is it a consulting company or is it an end client company? To have a real project, if those, why are they willing to wait until October? We need to investigate a little bit more further. What relationship do you have with that company? Then comes the consulting companies though. If they are consulting companies, we look into the address. We also look into how many LCAs they have filed for that particular location where their office location is. And then we will be able to determine, are there at least 30% of those people working at that particular location? If they are not, that definitely is not a good company. There are many other indications we can find. So there are some companies that we already know that they are blacklisted because we get the notice of intent to revoke. Then we know that these companies are blacklisted. We make a list of those things. So when somebody contacts next time, we know, okay, this company is already blacklisted. We keep it ourselves. We don't publish it, guys. I'm sorry about that. Yeah, there are indications that we also check with you. Did they interview you? Was there a technical interview? Was there an end client? If the end client did the end client interview when they filed the H-1B application, we do investigate all those things to find within reasonable certainty whether or not there is a collusion, but not 100%. We cannot tell 100%.
Phantom Jam says his H-1B was approved until 2026, but his wife's H-4 extension is still pending. The prior H-4 already expired April 27th. She lost her job because, of course, the H-4 extension and EAD didn't come through in time. And he wants to know, can she travel to India to get her H-4 stamped and then come back with that new I-94? And will that provide the automatic EAD extension? Okay, I'm assuming that the H-1B, H-4, and H-4 EAD were all timely filed before the H-1, H-4, and H-4 EAD expired. I'm assuming they all were expiring April 27th, 2023. So then your H-1B got approved, but under the new policy, they did not follow the new policy, and the H-4 and H-4 EAD remain pending. But the EAD was filed before the current EAD expired. If that's the case, yes, she can exit using your H-1B approval notice that's good till 2026, apply for the H-4 visa stamp, come back into the U.S. She'll get a new I-94 for her H-4 status that's good till 2026. Now that combined with her already filed I-765 receipt notice makes her authorized for the automatic EAD and extension, and she can go back to work. Now, if you had asked this question before April 27th, we would have said you can actually avoid stamping and go to Mexico because you can use automatic visa revalidation to come back showing her I-94 that has not yet expired because it's expiring April 27th. We're assuming that you came to us before this date, and show your H-1B approval notice for that's good till 2026. CBP will then give her an I-94 till 2026 to match the H-1B, and then she gets the auto extension as well. But since the old H-4 has already expired, the automatic revalidation in Mexico or Canada is not an option. The only option is to go to India to get the visa stamped.
Saiteja has this question. He has applied, he is registered with 7 H-1Bs. He got selected 1. Is that an issue? Absolutely, that's an issue. We do not recommend to file the H-1B with the company that got selected. I want you to wait for the next year to file only 1 H-1B next year, not 7 H-1Bs, because they already identified you. They're already telling that 408,000 applications have been received in duplicate. Out of that 408,177, the number might be a little bit here and there. There are 177, they remember 177. That 7 is yours because you told that you applied 7 times. They already identified you. So it is not right for you to continue with this process though. Now, is it okay? Can they still hit you with a misrepresentation? Yes, there is a chance for it. There is a chance. If you don't file the H-1B, we have at this point of time not seen the misrepresentation. That means when they issue the misrepresentation, it's going to be a lifetime ban for you. So we have not seen them. Now, could they do it? They can still do it, but we have not seen it. A lot of people are telling that, I've seen some of the other YouTubes recently just to find out those people initially that advocated for duplicate filings, multiple filings, and now they're retracting saying that, okay, USCIS is not an enforcement agency. They don't have any tool. They can't take any action. Not true. There are some actions they can take. 1, they can issue a notice of intent to revoke and revoke your H-1B. They can issue a notice of intent to deny and deny your H-1B. They can deny your H-1B transfer. They can deny your change of status to H-4. And out of all the most dangerous thing, they can hit you with a misrepresentation. That is a permanent bar for you. If the USCIS says that you have colluded in it and they have hit and they put that thing in the H-1B denial that you have misrepresented in filing multiple applications, which they have done in some of the cases, that means you have a permanent bar. You cannot come in on any other visa. The reason is that when you go to any other visa, even for H-4 or even for L-1 or L-2, there's a question that they'll ask, have you ever misrepresented in obtaining any of the immigration benefits? If you answer yes to that question, then you have to go to the waiver. If you answer no to that question, well, you already got hit with the USCIS telling you misrepresented. So you are in trouble either of those situations. You can't tell no because that will be a misrepresentation again. If you say yes, you have to go through the waiver process. This happens frequently. One of the recent example, Emily, what I want to cite to the people when they actually published these things was the OPT and STEM extensions. The employers who have used the most OPTs and STEM extension. Now, I did point it out this before to the audiences, but I want to reiterate that, is that when they published that, we were shocked to find out, of course, the top employers we found were Amazon, Google, Apple, Microsoft, Facebook, and so on and so on. Then we found this company called Integra Solution that was probably the number 2. I think so, it's after Amazon. And then we found number 5th or 6th was Aztec Solution. We never heard of these companies because we know top 20 companies. Not we, I would say everybody who file H-1B knows these companies. Now, all of a sudden, we find this Integra Solution to Aztec Solution. Now, for some reason, we didn't pay very much attention, though. But we started getting their F1 visas getting revoked because they use the Integra and Aztec. We couldn't figure it out why they were receiving the revocation notices for the visa stamping because they didn't mention that it is because of the Integra or Aztec. We were confused after a couple of consultations. My head was banging. Normally, we get the visa revocation for the DUI, which is driving under the influence of alcohol. That's fine. We know a solution. They go to India. They have to go to the medical examination, come back. It's definitely not a permanent bar for them. They have to just go through the hurdles. We initially thought this person has committed some crime, but no. And I put all the people together and find out what's the common thing in one conference call, then figured it out it was the Integra or it was the Aztec. And that was then afterwards, approximately around 4,000 to 5,000 people were being hit with misrepresentation for the Integra and Aztec solution. Now, these news doesn't come out much for you guys because you only hear the good news. So now they have identified the 400,000 people. Now you want to go ahead and file the application? Bad idea. Don't do that thing. Anything else, somebody, on what I said?
Nope. All right. Harsha is on H-1B and mentions that there's a tax credit program for solar power and wants to know if there's any problem if we use this tax credit. So the issue is it considered a public benefit that subjects you to the public charge ground of inadmissibility? So that's the basis for all of this. So for 100 years in immigration law, the law has always said that if you are coming into the U.S. and you are likely to be a public charge, meaning you can't care for yourself and you're going to go on welfare, then you can be denied a visa for that or denied a green card for that. Then Trump came around and talked about changing how we determine what is a public charge. And they started listing all of these different public benefits that could cause someone to be found to be inadmissible under the public charge provision. All of that went away after lawsuit, so it never went into effect. But there still is a list of specific public benefits that immigrants are not allowed to use. Tax credits is definitely not one of them, so no problem with that at all. What they're talking about is the actual welfare programs that immigrants who are here lawfully almost never can even apply for those because they get kicked out of the system. So it's very unusual for an employment-based, high-skilled immigrant to end up getting found to be inadmissible under the public charge because they use some sort of public benefit, because the benefits that someone to be a public charge are not, you're not even eligible to apply for them.
The question is coming out, can I withdraw from the second lottery application? Emily, I don't think so. They can withdraw the application.
No, it's already done. It's only the employer that can withdraw, but that has to be before the lottery is conducted.
I just want to point out, guys, there are certain parameters for the USCIS to fraudulently. We have expressed some of them when 200 H-1Bs filed by one company, company B files the same 200 H-1Bs. Definitely, that is a parameter for fraud. We have identified it can be 10, 20, 50, or something like that. That is a parameter because they're all collusion. It can be easily identified. But the USCIS also has some other parameters to see whether they want to do further investigation. When they see that a H-1B is selected in the lottery and the companies don't file the H-1B, that is a parameter for them for fraud because they know that you have applied from other things. Because you're not working for that particular company at that point of time, you did not file the H-1B. So that is a parameter. That means when company gets selected 100 H-1Bs, they only filed 10 H-1Bs. That is a parameter for fraud. So right now, these companies are damn if you file, damn if you don't file. Definitely, they should not file. I mean, I'm not recommending them to file, but I'm just telling. Still, that is a parameter for the USCIS to go into fraud. The second parameter that we have not expressed previously was that maybe you did, but I didn't. Is that when they see the H-1Bs filed with the internal project, and they move, these people don't work and move, within the first 30 days of October 1st. That's another parameter for fraud too. And out of all the things, though, the easiest thing that the USCIS is doing is FDNS. They send an officer there to ask the question, ask the employee the question, ask the employer the question, go inspect the employer location to see if the person is working there. That's another indication. Most of the fraud is getting through the FDNS. These field officers right now, Emily, there are like 3 or 4 officers in Houston and 4 or 5 officers, 7 or 8 officers in Dallas. They pretty much have the knowledge about the companies that are fraudulent. Now, just because they're not visiting them often doesn't mean that they're scot-free, but they know these are fraudulent, especially when they refer to the criminal prosecution, then they don't have to go there. They know that it's the district attorney that's going to take an action. Yeah, there are many parameters that the USCIS has. Don't think so that USCIS is sleeping. They have knowledge, guys. They have data much better than what you think.
Raisin says, can I file an H-1B for a part-time job? Yes, you absolutely can. You can do that even for your main job. You can do it as a concurrent. If it's a second job and you're only going to work 20 hours a week, that's fine. Even as your main job, though, you can file for part-time. But you don't want the hours and the pay to be so low that the government is wondering, how are you going to support yourself in the United States if you're only working 5 hours a week or something like that? But yes, H-1Bs can be filed for part-time employment.
Questions coming from Nitya, Vijiju from YouTube. Filed from 4 different companies. Only one company got selected. Should I go ahead and file the H-1B? Answer is no, don't. Vijiju has filed for multiple different companies, got selected with only one company. Is that particular candidate safe? No, they're not safe. Here is one rule, guys. If you filed H-1B with one company that you are already working for that company, don't contact us, you're good. File with one company, you're working for that company right now, and you're working for that company in March, you're good. But if you filed with multiple companies, okay, period at this point of time, please consult a lawyer because we want you as safe as possible. We don't want a lifetime ban on you. Damn hell with the companies, okay? We want to save you and do hell with the companies. That's our motto. Number one rule is that if you file with one company and that company you're working, you're good. Don't consult us, you're good, sir. But if anything else, you file 2, please consult us or consult some other lawyer, competent lawyer who has been advocating from the beginning. Don't file these duplicate applications.
Yash says, do you think EB1 India will move forward in October 2023? His priority date is August 2022. Well, we have to go back to pre-COVID to really answer this question. And you may not be aware, but prior to COVID, EB1 India was backlogged for a very long time. So if we look at the September 2020 visa bulletin, it was backlogged then by about 2.5 years. The only thing that took away the retrogression in EB1 India was the spillover from the family base that we got for those 2 years during COVID. That spillover is ending this year. We don't expect to see more of that next year. More and more people are filing in EB1 because they're sick of waiting in EB2 and EB3, and those dates aren't going anywhere. So no, I do not expect EB1 to move forward much, if at all, in October, just because we're getting another round of green cards. I expect we're going to go back to how things were prior to October 2020. And even in going all the way back to, let's go back to April 2020. That was 3 years ago, a little over 3 years ago. EB1 India was backlogged 4 years, 11 months, and that lasted for a number of months. That went all the way back to 2019. So we're definitely going backwards, not forwards for EB1, unfortunately.
Is severance pay considered to be in the part of the 60-day grace period or not? I mean, does the 60-day grace period starts after the severance pay? At this point of time, even though the USCIS website reading says that the day you got laid off is when the 60-day grace period starts, but we have seen the USCIS interpreting differently, though. They're telling severance pay is after the severance pay is when your 60 days starts, but we never know when they will change their opinion.
Saravana says, can I file the first time H-4 EAD alone with the I-140 to avail the premium processing? No. The I-140 is completely separate from the H-4 EAD. The only application you can file an H-4 EAD with is the H-1B or the H-4, but you can't file one with an I-140 because you don't qualify for the H-4 EAD until after the I-140 is approved.
Some people are saying that they steal mails, manipulate addresses, and threaten the people at their home country. I never heard of that, though. I'm very surprised that India is a law-abiding country too. I mean, you can't just threaten a person in India. Just like that, if you do, you should contact a lawyer in India. They should be able to help you out. Obviously, you should. It's easy in USA to just contact the USCIS and inform them. They will take these actions, and they will be in the jail for a long period of time. And if you have any evidence that they are doing it, please collect it and give it to the USCIS. Give them the specific information.
Neeraj says, is it possible to come back on H-4 if the H-1B stamping received a 221G and apply for the H-4 stamp to come back? So it's definitely possible to apply for the H-4 stamp if your spouse is in the U.S. on H-1B. The problem is your H-4 stamp may also be hit with the 221G because we don't know the reason behind the 221G. Is it because of past history with Integro or AZ Tech or something like that, or some past duplicate registrations? We don't know what the issue is with the H-1B that's causing the 221G. Are they investigating some kind of potential fraud or misrepresentation that doesn't go away just because you're now applying for the H-4? Now, if they're investigating something with the company or the project or something like that for the H-1B, then it may be slightly more likely that the H-4 can be issued without another 221G. But there's definitely that risk there, so it's not necessarily going to solve the problem.
Rohan Paul from Facebook has this question: can you work at two places on H-1B? I don't understand exactly when you say two places means two different locations in Dallas and probably in San Jose, or is it company A and company B? Both can be done. I mean, you can work 30 days in Dallas and 30 days in San Jose. They just need to file the LCA for both the locations, though. Can you work for company A and company B at the same time? Absolutely. This is called concurrently filed H-1B. You can do so without any problem. We have made a separate video on it, and a lot of people are working. You can do so legally, work for two companies at the same time.
Clevy says, when do you expect rest of world EB2 and EB3 to become current? What's your best guess? Typically, those do become current in October when the following year's visa numbers come out. So we do often see retrogression of rest of world that happens later in the fiscal year, usually in the summer, as more and more demand pops up. And those visa numbers get used up, then retrogression happens, but then it clears up when the new fiscal year starts in October, typically.
Will the multiple registration filed this year can cause a problem in the next year registration? Yes, they can. Because they have identified the people who have done the multiple registration, it may cause a problem next year too.
Gmail user says, does the size of the company matter when applying for an H-1B? I work for a startup and my lottery wasn't picked. So it does not matter in the lottery. It truly is a lottery and they'll pick randomly, as you can see with all the disingenuous registrations that they picked. The size of the company can come up in the H-1B petition filing once you're selected. I haven't seen a lot of pushback or questions on startup companies for H-1Bs within the last couple of years. I haven't even gotten an RFE on one in quite some time. In prior administrations, they would always question, number one, vibe. So there's this verification of business existence that USCIS does pretty much on every company for every filing. So they're going to look up, what does the vibe system say about this company? And if it's a new company, it might have no information at all. It takes information from Dun & Bradstreet as well as quarterly payroll reports and public information that's available for different secretaries of state where company filings are done. So if there's nothing in vibe, you'll get a request for evidence asking for proof of the tax ID number, proof of the company address, like provide a utility bill or your lease agreement or photos or things like that. So that's pretty easy to overcome. But then they can also question, are the job duties something that this person will be, what they say, relieved from non-qualifying functions? Because the H-1B is only for specialty occupation work. So they want to make sure that when you're on H-1B with a startup company, that you're not also the one who's going to the bank and making copies and running payroll and things like that, that are non-qualifying H-1B functions, because you don't need a bachelor's degree in a specific field to do those. So those are the common things that come up after the H-1B is filed, but it doesn't have anything to do with the lottery.
Gaurav Reddy has this question. He got the H-1B approved in 2022. He's going for India for stamping. Is it going to be a problem if the company has done multiple registrations? Yes, if the company has done multiple registration, they may hit you with a misrepresentation. You may want to investigate very thoroughly. But as I said, if you work with the company before they file the H-1B, and you only filed H-1B with that particular company only, you have a very good defense, though. So a question that is asked is, how long does it take? This is from Jen Mishra from YouTube. How long does it take for the USCIS to issue a notice of intent to revoke? And will it affect the green card application? Previously, we were seeing normally intent to revoke 3 years from the time the H-1B has been getting approved. But nowadays, we are seeing within 1 year, we see a notice of intent to revoke. The timeline has done very good. I wish they would deny before itself, so that people who are filing these fraudulent applications are not encouraged, but unfortunately, it's not. So 3 years is what it used to be. It's now 1 year is the time. Yes, we have seen it affected in the 485. If the first H-1B application is a fraudulent application, the foundation is a problem for you, because all subsequent H-1Bs are counting on the first H-1B. So they may have a problem for you in the 485 also.
Madhumita says, my H-1B is approved. Can I go for stamping in the U.S. itself? Not yet. So we still have to only go for stamping outside the U.S. at a consulate. USCIS or Department of State did announce about a year ago that they were looking at stateside visa processing, and then there were some articles late last year that seemed like they were planning to go ahead with it. There was some rumor that maybe they would try to implement it by this summer. Have not heard any updates on that. Not really any rumblings or anyone's talking about it right now. It should be coming, but we don't know when at this point.
Muhammad Ali has applied for multiple different companies, but did not get selected any of those things. We don't know at this point of time. We have not seen any enforcement for these kind of things, but could they do it? We don't know. There is a chance they may enforce it and put a ban on you. Especially we have seen that in the Integra and Aztec. A lot of those people who got affected by those things were permanently barred. But at this point of time, the people who have never filed the H-1B, even though they may have filed the lottery, they may have got selected in the lottery, who never filed, we have never seen any action from USCIS or the Department of State or the CBP at this point of time.
Job says, my H-1B was picked and now I'm on H-4. Can I travel to India before October this year? So potentially, depends on the timing of the filing of the H-1B and whether you're intending to get it approved as a change of status, which we do recommend. So if you can travel earlier and come back before June 30th and then file the change of status to H-1B by June 30th, that is a good option to do. Then you don't have any problems with the H-1B change of status. If you have filed the change of status and then you travel before it gets approved, that's going to abandon the change of status request. That means your petition, the H-1B, will still be approved, but without an I-94, it won't put you in H-1B status beginning on October 1st. You're either going to have to travel again and get the H-1B stamp, or have your company file the H-1B again to get the change of status approved after you've returned to the U.S. If you have already received the change of status approval before October 1st, and then you travel and come back on H-4 before October 1st, the H-1B change of status can still kick in on October 1st, but it does cause some issues for I-94 number mismatches, because the I-94 number on your H-1B approval notice is going to be different than your current I-94 number that you got when you entered on H-4, and that can create problems for driver's license renewals, getting the social security number, and things like that. So you may want to travel again and use automatic visa revalidation in Mexico to come back on H-1B after October 1st if you're in that last situation.
Adi has this question, can I rent a car for Toro? No, you can on H-1B. Speaking about an H-1B, of course, we don't give consultations to green card holders and citizens. That's not our specialty. This is on H-1B. The answer is no. The reason is that renting a car to the Toro involves a lot of personal involvement in there. It's not like you just give a rent and then you forget about it, because every day you have to service it, you have to give it back to the customers, you have to select if or not you're accepting that particular person. So definitely not allowed on H-1B.
Kalavakuri says, do you think USCIS will continue this same process for the electronic registration because they make so much money off the $10 filing fee, even though they know about all this fraud? Well, imagine when that $10 filing fee goes up to $215, which is already the plan for next year. It's not finalized
not good
yet,
enough. Not
but
good
that's
enough, man.
not going to fix the fraud for sure. So yeah, they're going to get even more money, 20 times more money next year without fixing the fraud. So I think their process has always been so backwards that we're going to find the fraud after everything is done. And just with the numbers the way they are now, it's so clear that they are really making it tough for legitimate people to get selected, to where the lottery is practically useless right now. So I think they've got to make some changes now. What those changes will be is anybody's guess. But on top of that, they're planning on increasing that fee to $215.
Sai has this question, can I change the H-1B approval to the change of status after it's been approved in the consular processing? Yes, you can. you have to reapply the H-1B and apply for a change of status. And you don't have to go to the lottery system. You're good. You don't have to apply in the lottery. You just apply for a change of status. But we strongly recommend people who can apply for change of status to apply for change of status instead of applying the consular processing.
Palash says, my AOS case status says case remains pending, even though my priority date is current and documentarily complete. USCIS says I can reach out to them after 15 months. So that's their current processing time. And he wants to know, what are the next steps? Should I reach out to a senator? So in our experience, reaching out to a senator doesn't work anymore. Reaching out to a congressman doesn't work anymore because according to USCIS, the case is within normal processing times. Clearly, 15 months for one application is not normal. So the best thing to do at this point is to file a lawsuit. We have continued to do those for AOS delays and EAD delays and advanced parole delays. So you can reach out to our team if you want more information about that process. But that's likely going to be your next step other than just waiting.
Anything else, Emily?
Nope, I think we're out of time for today. Thanks so much for joining us. Don't forget, we have a daily conference call that you can join for free to get your questions answered there. You can go to rnlawgroup.com to get that information. And you can also, while you're there, sign up for our newsletter that comes out every Wednesday so you can get the latest updates from our team.
Thank you for tuning in.